Assalamualaikum warahmatullahi wabarakatuh. In this presentation, I will be discussing an article entitled Kafala on Mudharabah Capital, which was issued by the Sharia Advisory Council of the Security Commission Malaysia in the year 2001. This article is categorized as Sharia juristic resolution, meaning that it represents an authoritative fatwa-based regulatory decision rather than a purely theoretical academic discussions. The resolution addresses a very important issue in Islamic capital market, particularly the question of whether capital invested under a mudharabah arrangement may be protected through the use of kafala or guarantee. This issue is highly relevant because it involves a direct interaction between classical Islamic jurisprudence and the practical needs of modern financial market. Throughout the presentation, I will explain the background of the article, identify the key Sharia issue, analyze the SSC reasoning, and discuss the finding and implication of these resolutions. To begin with, Islamic capital market operate within a Sharia framework that strongly emphasizes fairness, transparency, and justice between contracting parties. One of the most fundamental principles underlying Islamic finance is risk sharing, where returns are justified only when accompanied by exposure to risk. Mudharabah is one of the key contracts that embodies this principle. It involves a partnership between a capital provider known as the Rab al-Mal and an entrepreneur or mudarrib who manage the investment. Under the arrangement, profits are shared according to a pre-agreed ratio, while any financial loss must be borne entirely by the capital provider, provided there is no negligence or misconduct by the mudarrib. While the structure reflects Sharia ideals, it also creates challenges in modern financial market. Many contemporary investors are risk-averse and expect some degree of capital protection. As a result, the absence of any form of guarantee may reduce investor confidence and limit the attractiveness of mudharabah-based product. It is within this context that the concept of kafala or guarantee becomes highly relevant. This article responds directly to these challenges by examining whether investor protections can be enhanced without violating the core principle of Sharia. Moving on the purpose of the article, the main objective of this resolution is to examine whether kafala can be applied to mudharabah capital in Sharia-compliant manner. More specifically, the article focuses on guarantees provided by third parties rather than by the mudarrib himself. This distinction is extremely important from a Sharia perspective. The resolution seeks to address the apparent conflict between classical Islamic jurisprudence, which strictly prohibits capital guarantee in mudharabah, and the practical demands of modern Islamic capital market. In today's financial environment, Islamic investment product must remain competitive with conventional alternatives while still preserving their ethical and Sharia foundations. Therefore, this article is significant because it offers regulatory clarity and authoritative guidance on how mudharabah-based investment product may be structured without compromising Sharia principle. It also demonstrates the role of Sharia governance institutions such as the SSC in ensuring that Islamic finance continues to evolve responsibly in response to market realities. After discussing the background and purpose of the article, I will now move on the identification of the key Sharia issue highlighted in this resolution. The central issue addressed by the CAC arises from a clear tension between two competing considerations. On one hand, mudharabah is fundamentally based on the principle of risk sharing, where the investor must bear the risk of capital loss. On the other hand, modern investors increasingly demand capital protection. These tensions raises important questions about whether providing guarantee undermines the essence of mudharabah. The article therefore examines several interrelated issues including the prohibition of capital guarantee by the mudarrib, the permissibility of guarantee provided by third party, and the Sharia basis upon which such guarantee may be structured. In addition, the article also considers alternative mechanisms such as reserve funds and layered investment structure, which aim to enhance investor protection without violating Sharia principle. Collectively, this issue demonstrates the complexity of applying classical mudarabah rules within contemporary Islamic capital market. The first and most fundamental issue discussed in the article concerns capital guarantee provided by the mudarrib himself. Classical Islamic jurists from all major schools of thought unanimously agree that such guarantees are impermissible. This is because the mudarrib acts as a trust or amin who manages the capital on behalf of the investor. Guaranteeing the capital will contradict this trust relationship and transform mudarabah into a risk-free arrangement that closely resembles a loan. From a Sharia perspective, this violates the muqtada al-aqd or the essential nature of the contract. The article further highlights that jurists differ on the legal consequences of including such a condition, while some schools consider the contract valid but nullify that guarantee, others regard the entire contract as invalid. This discussion reinforces the importance of preserving genuine risk-sharing as the foundation of mudarabah. The second issue addressed by the article concerns guarantee provided by third parties who are independent of the mudarabah contract. Unlike guarantee by the mudarrib, third-party guarantees do not directly alter the contractual relationship between the investor and the entrepreneur. However, the concerns lie in whether such guarantees indirectly shift investment risk away from the capital provider, thereby undermining the spirit of risk sharing. This issue becomes particularly significant in structured investment products commonly used in Islamic capital markets, where multiple parties and layers of protection may be involved. The challenge, therefore, is to ensure that third-party guarantees do not distort the substance of mudarabah while still providing confidence to investors. Another key issue discussed in the article relates to the basis upon which third-party guarantees are provided. The article distinguishes between guarantee based on tabarru, which are voluntary and non-compensatory in nature, and those based on card or loans. Tabarru-based guarantees are generally accepted by contemporary jurists because they do not involve any expectation of return and therefore do not resemble interest-based transactions. In contrast, guarantees structured on card raise serious Sharia concerns as they resemble debt obligation and may lead to riba-related implications. The CAC adopt a cautious approach by rejecting debt-based guarantee, reflecting its commitment to preventing Sharia circumvention. In this Sharia analysis, the CAC begins by clarifying the concept of kafala. Kafala is defined as a contractual guarantee that combines the liability of the guarantor with that of the guaranteed parties. The CAC focused specifically on kafala bil mal, which refer to financial guarantees, as this is the most relevant form in the context of capital market. The resolution firmly reaffirms the classical prohibition against guarantee provided by the mudarrib. At the same time, the CAC adopts a nuanced and principled approach by permitting guarantees from independent third parties, provided that such guarantees are not stipulated as conditions within the mudarabah contract itself. These distinctions allow investor protection to be enhanced without undermining the core Sharia principle governing mudarabah. The CAC justifies its position primarily through the concept of tabarruk. This approach is supported by resolution issued by international Sharia bodies, which recognize voluntary guarantees as permissible under Islamic law. More importantly, the resolution aligns with the broader objective of Sharia, known as Maqasid al-Sharia. In particular, it supports the protection of wealth or hifz al-mal by safeguarding investor interests through permissible means. This demonstrates that Sharia is not rigid but rather capable of responding to contemporary financial challenges while maintaining its ethical foundations. The main finding of this article is that third-party guarantees on mudarabah capital are permissible under Sharia, provided that they are properly structured. This finding has significant implications for Islamic capital market. Firstly, it enhances investor confidence by offering Sharia-compliant mechanism for capital protection. Secondly, it encourages innovation in Islamic financial products by allowing institutions to design investment structure that balance risk sharing with financial stability. Finally, the resolution provides regulatory clarity, which is essential for effective Sharia governance and standardization within the industry. In conclusion, the article Kafala on Mudarabah Capital offers a comprehensive and authoritative Sharia analysis of a critical issue in Islamic capital market. By permitting third-party guarantees under strict conditions, the CAC successfully reconciled classical Mudarabah principle with contemporary financial realities. The resolution preserved the essence of risk sharing while providing a Sharia-compliant avenue for investor protection. Ultimately, this article contributes meaningfully to the growth, stability, and credibility of Islamic finance, both in Malaysia and globally.